Hi, everyone. Welcome to the Keeping Your Business Together in a Crisis live stream webinar series. This is part 15, Legal Questions. We are very fortunate to have two fantastic panelists from Launch Legal and Davis Graham and Stubbs that also represent the Colorado COVID Small Business Legal Program. This program is a group of volunteer lawyers from across Colorado that have rallied together to help small businesses survive and get back on their feet. These law firms from around the state have joined with the Attorney General along with Colorado Office of Economic Development and International Trade and the Colorado Lawyers Committee to launch coloradocovidrelief.org and to provide pro bono legal services to small Colorado businesses. Many of them are minority and women-owned. I've added the link to the CLC website as well as the Colorado COVID Relief site to our slide, so you can see that. And Jamie will announce again that those URLs to help you get legal assistance at the end of the presentation. We're recording this session at 10 a.m. on Wednesday, July 22nd. And our next webinar, which will be next Wednesday at 10 o'clock, will focus on answering TPP questions for forgiveness and for application in a live stream Q&A with subject matter experts Dan King and Brian Ormsby. I'd also like to give a special thanks to Nikki Maloney for helping to connect us with our great panelists today, and also for doing an awesome job at providing information to all the SBDCs around the state. She sends out updates that are awesome. This series is produced by the Boulder Small Business Development Center to support businesses in Boulder County as well as the rest of the state through our TechSource program. We're one of 15 SBDCs in Colorado, and I know some of you are dialing in from other areas, particularly some of the rural areas in Colorado. So if you're looking for the center closest to you, you can visit coloradosbdc.org. And again, Jamie will probably say that again at the end of this session. Our center is hosted by the City of Boulder, and we're part of an awesome group of local, state, and national strategic partners that can help you during these challenging times. We have everyone on mute right now, so if you have questions, which I'm sure you might if you've dialed into this, go ahead and put those in the chat, and Jamie and I will be asking those after we cover some of the questions that have already been submitted for our panelists. There's a link to this recording that will be sent to you tomorrow, so you don't have to worry about capturing everything at this second. We'll also post it on our website for you to listen to again at your leisure. And now I'd like to introduce our speakers. Yev Muchnick, founding partner of Launch Legal LLC, and Maria Oxman, attorney at Davis Graham and Stubbs. Thank you, ladies, so much for being here, and my co-moderator, Jamie Brandis. So, Jamie, you want to take it away?
Sure. So the first question we have is for Maria. And Maria, if you just want to give a little bit of your background before you answer, or a little bit about your firm, please feel free to do that. But the question, I will say, is this person is unable to pay rent because they've been closed since April. What advice would you give to how to renegotiate that lease?
Hi there, everyone. Like they say, my name is Maria Oxman. I've been at Davis Graham and Stubbs for, I believe, 4 or 5 years, and we practice in a lot of different areas, but I specialize in real estate and specifically in leasing, commercial leasing, and also acquisitions and loans. I, however, don't do litigation, so if at any point I make reference to that again, please take note that I do not practice litigation. We usually hand that to the litigation group. So with that, I think when it comes to a commercial lease, we have to take a step back and try to figure out, in talking with a lot of tenants, I think some are very unclear as to what the next steps are, and that is very understandable. But I think the first thing you need to sit down and try to decide is, what do you want? And so the question relates to like inability to pay rent. But so I invite you to ask yourself, what is my ultimate goal here? Am I going to be a viable business after COVID, or am I just trying to wrap up my business? And having that in mind, then you can, I think my first advice, which is not very legal, but it's just communicate with your landlord. Don't let months and months go by and you just don't make payments and you just don't let them know what's going on, because you have to think landlords are also maybe small businesses themselves, and they have to pay their mortgage, and they need to communicate with their lenders if they're having issues with collecting rent. You also have some landlords that will tell you, don't worry about rent for the next few months, but unless you communicate, you can't really know what they're thinking about, and you can't really work together towards a solution. And the other thing to keep in mind for landlords is that, you know, they are, with exceptions, of course, but most likely, if you have been a good tenant, they would rather work with you than have to go through the process of trying to figure out how to get you out of there, particularly with how the court system is going to be very busy within the next few months. So if you think that you will have a viable business and you want to work with that landlord, you better communicate with them. And that is the communication with your landlord. You should also reach out to an attorney. And I know that small business, I mean, this is, you are trying to cut on expenses. So I just want to re-emphasize what Susie said. There is the Colorado Lawyers Committee, and they put together the Small Business Clinic. And what it is basically a matching program where you tell them in your application what is your specific problem, and then they send all these different businesses issues to a listserv of attorneys that have already said that they are willing to take on pro bono cases, and then they try to match you up with an attorney that can help you with very specific questions. So that's that. So now here's your, of course, you can try to negotiate everything under the sun with your landlord, but here's what we're seeing that they are doing. So like I said, there's some landlords that may just say, you know, this is a tough time, don't worry about it. A lot of landlords, however, want to come out whole from this. And so they are trying to come up with ideas to basically defer rent or forgive rent, but then make up for it in some other way. So some ideas are, for example, they can reduce your rent significantly during this period of time where you cannot operate at a full capacity, but then they would amortize that rent that you haven't been able to pay through the remainder of the term. So you will be making higher rent payments. Another option that I've seen is they have forgiven the rent for 2, 3, 4 months, but then they add up to the term of the lease the proportionate amount of months. So if they forgave 3 months, they would add that to the end of the lease so that they can eventually make up that for that difference. I have also seen, you know, a lot of tenants find themselves in the situation where they just took possession of the space, or where they are still working on their tenant improvements and they haven't quite taken possession of the space. So I have seen that landlords have agreed to, for example, take on more tenant costs themselves for the initial improvements, and then delay the start date. But then again, they're either increasing rent at the back end or increasing the term of the lease. So For someone, and that was a roundabout way of going to the question, but for someone that has simply not paid any rent, then I think at this point you need to contact someone that may turn into litigation unless you try to contact your landlord and try to reach another, make an attempt at reaching an agreement at this point. And then you would have, some landlords are requiring personal finances. A lot of retail leases have a personal guarantee. So if you are in that situation at this point, I think you need to be thinking about a lot of different things. You need to be thinking about bankruptcy. You need to be thinking about a possible litigation and all those. And then, Jamie, do you want me to cover force majeure and maybe some other arguments in different questions, or should I just cover it now?
You can cover it now. I think that was
I would say go ahead.
Yeah, okay. And so some tenants have actually been asking about, what about impossibility? What about impracticability? What about frustration of purpose? And now I come back to my caveat that I'm not a litigator, so it's difficult to say how courts are going to react to this. There is at least one case in, I think, Illinois, but that I'm aware of, nothing in Colorado yet, that talked about how you could be partially excused for the rent due to your inability to stay open, but that, that really related specifically to a stay-at-home order. And then when they were able to reopen and there were some capacity limitations, the court said that maybe you could reduce the rent, but again, this is not in Colorado, so it is difficult for us to determine how the courts are going to react to this. So I would say, talk to someone that does litigation and see if there is any recent cases or if they see any trend in that respect. So now I know a lot of people are wondering about the force majeure clause, and I just want to start with some general caveats from that clause. The force majeure provision is normally general, very, very narrow, or general, depending on how you look at it, if you're landlord or tenant. Sometimes it would only benefit the landlord. Sometimes it's reciprocal. So it is very difficult to give advice or a general thoughts on how the clause works, because it really depends a lot on how it has been written. So if, for example, it only works for the landlord's benefit, then you are going to have a difficult time claiming that you are also able to use it. Now, if it is reciprocal, very, very often the clause will say the obligations of the parties may be delayed due to a force majeure, except for the payment of monies. And so that puts you in a difficult position, because you can, in that way, that clause could be used. For example, you had some maintenance obligations, and due to COVID or any other force majeure, you weren't able to fix your HVAC unit in February because there was the stay-at-home order, and then landlord will be okay with you delaying that performance until the HVAC company is able to come and look at it. However, if it says that you can't excuse the payment of rent, then you are going to have a difficult time. Some, however, are drafting general terms, and then you can get into detail about what is force majeure. Sometimes they don't define it. Sometimes they go into very specific items, hurricanes, earthquakes, and it will include acts of God. So it's, it's, again, we have to read it to figure out, would that cover COVID? Most likely it will, but again, they're drafted in so many different ways that you would have to see. And so then my last thought about force majeure is that the purpose of this is to delay performance, but not necessarily excuse it. So you can, unless it's drafted differently, generally it would help you in arguing with landlord and say, I really was completely shut down for April and May. I'm not able to pay rent right now. Can you please, and that's when you would come and propose some of the other options. Can you please defer it? Can you please forgive it? Could you please extend the term? Or any of those other options. You can have, we've had cases where all we needed to do was tell the landlord, the tenant needed to do is tell the landlord, hey, I have an attorney helping me out, and then all of a sudden landlord is very willing to negotiate. Then we've had other cases where I think the vast majority of cases are not coming to attorneys because the parties are just communicating amongst themselves and they work something out. I would advise you, if that's the case, to put an amendment in place just to memorialize the agreement between the parties. And there's others where we've needed a little more nudging and where we have basically, drafted a letter to landlord explaining our position and explaining why they should at least entertain the option of coming to an agreement. But in a lot of cases, it's really, I mean, landlords are not obligated to do it, but again, we get the impression that they should have an interest in doing it, because otherwise they're going to have an empty space, and depending on what industry you're in, they may have a very difficult time reletting that space. Now, with what you want to do, so those are options when you decided at first that you want to keep going and your business is hopefully going to be okay in the long term, and this is going to be a couple difficult months, but then you'll be able to come out of this. Now, if you want to terminate the lease, that is a different story. So that you can either, again, try to negotiate something with the landlord and say, look, can we negotiate a buyout? Can I pay you something so I can get out of the lease? Like, what are your thoughts? Because in theory, you are obligated under the lease. That's when the frustration of purpose and all this can come into place, but where I don't feel comfortable saying, yes, you definitely have an argument there. Where probably someone that does litigation would be better able to tell you, or maybe not, because we just don't know how the courts are going to take on this. So then you would have to determine, and usually, and correct me if I'm wrong, but attorney, I mean, I can't make the determination of damages, but someone can help you determine, okay, from reading the lease, how much money am I going to be on the hook for if I just vacate the premises? And that's when you, I think, make the analysis of bankruptcy. That's where you take things to the other level and determine what's going to be the less costly option in getting out of my obligations. If this is really coming down to I cannot operate anymore.
Yeah, I mean, I would definitely agree with that.
Yeah.
So a lot of times it's just this gray area of balancing, and when we're in uncharted territory at the moment, so we don't have much precedent to go off of across the board, whether it's real estate or any other industry.
So yes, first, would you please tell us a little bit about your background, and then I think it would be great if you could. A lot of people are asking about startups and what they need to consider if they have investors right now, and I know you have a ton of experience with that, so maybe it'd be great to start off with your thoughts around that after you share a little bit about you.
Sure. So thank you very much again for having me. My name is Yev Mochnik. I am a corporate transactional attorney, and I do securities work as well. I focus primarily on working with startups and tech companies across a number of diverse industries, including healthcare, AI, blockchain, just across the board. And that's really what ignites me and makes me love my job so much. Currently I work in my own boutique firm called Launch Legal, based out of Denver, Colorado. But by way of background, I started at Squire Patton Boggs. I was general counsel for a publicly traded company, and then for a private aviation tech startup, and then moved into my own boutique firm counseling startups. So yeah, I mean, that's a very much a topical issue for a lot of my clients and the companies that I advise and founders, and they're kind of in a state of in a state of flux, just because they don't know how to prepare for funding and for the future. So I think there's a lot of focus and effort on negotiating term sheets and trying to lock them down now, as opposed to kind of what's being predicted in the fourth quarter of this year and the second wave of this pandemic. But term sheets are generally non-binding. There are some binding provisions that you will find in term sheets, but typically they relate to kind of confidentiality and provisions that don't really lock in the investment with investors. So whether you could sort of negotiate now and lock in a closing date for funding your company is to be determined. I think everybody's really trying to feel it out. So there's, again, no kind of consistent advice that I can offer in securing your investment. But then again, just kind of once you do lock in that term sheet and you're in the stage of drafting the definitive documentation for the investment, I guess I would also look at force majeure clauses on both the side of the investor coming in and what they're negotiating in, and whether they can pull out before closing, or whether there are any other kind of clawback provisions that are atypical to kind of the standard purchase agreement that we've been seeing. But then also on the side of the company, and if there are funding tranches, for example, that are tied to milestone events and performance of the company, that there's wiggle room, or there's some kind of mitigating language that allows you to extend performance out past the set deadlines or timelines for funding in that agreement. So that would be kind of the primary thing that I would look for. But it's we've had, even in kind of the robust economy period, which we've experienced over the last couple of years, we've had investors pull out right up to the date of closing. So I mean, it's just you kind of cross your fingers and your toes and hope for the best. But obviously, advising with counsel and seeing whether if the payments are tied to particular events and performance of the company, that those are now kind of looked through a different lens based on economic circumstances.
Great, thank you.
Great. Thank you. So I have a question for both of you, if you're both up for answering it. So I think there are some people that are concerned as they're, opening again, that if a client were to get sick, as they're coming in or in any circumstance, is there some kind of paperwork or form that people can get that covers liability for if a client does get sick that they meet with?
So we're just differentiating between client versus employees, right, that are in their workplace specifically.
Yeah, and I think it would be helpful if you could touch on both, but this one was specific to clients.
Yeah, I mean, sure. Again, from my perspective, I'm going to continue to repeat the statement, and I know that it's not particularly helpful, and I hate when lawyers do this because people dislike lawyers for all the carve outs and the disclaimers and the caveats, but it's just, we just don't have enough precedent, right? So if you're asking people to sign liability waivers, we don't know if they're enforceable or not. And OSHA, for the employee part, OSHA hasn't determined that the COVID or the pandemic has risen to the level of a hazardous workplace. So again, it depends what will happen in litigation. And I, like Maria, am not a litigator. So I mean, you can, it's always it's always advisable to CYA and to try to cover yourself as much as possible. So having some sort of liability waivers in place, may do you good. But otherwise, I mean, I think my strongest recommendation would be to follow the state guidelines and what's being released on through executive orders by Governor Polis, and just continue to check those updates, because kind of the closer that you can show that you've made a good faith effort to comply with those, the more that will be on your side if there is a claim against you.
So I'm going to echo Yevin in that sense that although we don't know what is going to happen, you would want to have evidence that you made commercially reasonable efforts to take care of following the guidelines and making sure, sending people communications about the protocols that you're following and all that. That said, if you want something more specific for your business, I would again encourage you to reach out to the Colorado Lawyers Committee. I know, some colleagues from my firm have specifically marked up we've done it for hospitality businesses, we've done it for spas, nail salons, so places where you really see a lot of traffic of people. You usually have something in place anyways that you sign before, say you get a facial. Those are already in place. So what we have been doing, I haven't done it personally, but it's something that I'm sure an attorney can help you on a pro bono basis, is just to mark it up to add some provisions. And again, what the effect of those are going to be remain to be seen, but at least you have made reasonable efforts to address it in your regular disclaimer and waiver documents.
Yeah, I mean, and for example, just an actual example, and again, I didn't advise them, I'm not their lawyer, but my kids are at DU for summer camp this week, and so we are having to sign daily waivers, which within 2 hours of them being at the camp, making sure that, well, we had like a liability waiver that we signed, and then also a disclosure as to symptoms and kind of like a health check. So, I mean, I think all of those things are sound business practices, right? To say, look, one, we're shifting responsibility on you as well to make those kind of disclosures, and then we're also taking some responsibility on our side to mitigate any issues that do come up.
Great. Maria, just a quick question about title companies. Do you know if title companies will continue to facilitate transactions and issue title policies during the quarantine period?
So yes, absolutely, and those guys have been rock stars. Honestly, I had a pretty big closing during lockdown, like during the first few weeks where you couldn't even, the notarization wasn't clear. You would have to ask your title company how they're doing that now, because at least for our transaction, the particular title company that we were working with, had a threshold where anything over $1 million, they wouldn't allow for remote notarization. So this was, several $1 million transactions. So they had, we've had to have the CEO meet with a mask outside with a notary, and it was really fun the way they made it work. I mean, those guys are really making it work. And so I've had a number of closings during this whole period, both commercial, a few residentials. Just by the way, anecdotally, we have been, for whatever reason, I've closed a couple of deals in somewhat rural areas or more recreational, like, near national parks and all that. And they're very busy. They have never been this busy. A lot of people are either moving out of the city and all that. So yes, they continue to operate. We've done mostly everything online. A lot of times they accept e-signatures, of course, not as it relates to anything that needs to be notarized. But other than that, they even connect you with the. So now there's a number of companies that are offering remote, curbside notarization. So that's been very easy. So they'll connect you to the folks that you need to be connected with. But they really have been operating as business as usual. So that's been really nice.
Great. Thank you.
Thank you. So Yev, I have some questions about bringing staff back. So one is, are there some best practices for bringing staff back on board? And then also, if someone has been offered their employment back, but they have concerns about coming back related to COVID and they basically refuse to come back, is there anything that the business needs to legally do to protect themselves?
Sure. Yeah, a very important question. So again, I would reference back to the state recommendations on bringing employees back. And there are specific guidelines in an executive order. So one, just vulnerable individuals should not return to work. And those are classified as persons aged over 65, pregnant women, those that have heart and lung problems, that are immunocompromised, and have been determined to be high risk by a licensed healthcare provider. So those have specifically been kind of itemized as vulnerable persons who should not return to work. And then employers should, if they can make some kind of accommodations for childcare, that's also encouraged. But if such employees are also in the same household as vulnerable individuals, then again, the same kind of precaution should be taken. And then just again, with respect to capacity, that only 50% of your workforce should really be returning to work, and the rest should be kind of phased or cycled in and out. And then to the extent, I think personally that this is, a great lesson for a lot of companies to show that virtual and remote employment is really possible, not for everybody, obviously, but to those that are and that have been able to accommodate, there are certainly, this has been the proof in the pudding. So yeah, and again, just kind of face masks and covering, keeping 6 feet apart. Those are the state guidelines, having hand sanitizer and installing plastic protective shields, which we've seen the majority of the stores now. And then there's required signage that is also linked to on the state website. And the state website is, just in case anybody doesn't know, is just www.colorado.gov, and you'll see there's a page that says return to work guidance for workers and for employers. So, and then as far as those that are concerned about returning back to work with the pandemic, on the employer side, If somebody hasn't accepted an offer, then obviously you still have sort of the latitude to rescind that offer. If somebody is concerned about returning to work but don't fall under the vulnerable person category, again, it's a little bit of a gray area because kind of OSHA hasn't made that ruling that it is a dangerous workspace. So there was so just looking at one case that did come out, a court denied an injunction to pork plant workers that asserted the plant was not doing enough to protect employees. And then the Secretary of Labor has also said that COVID cannot be treated like other workplace hazards because it is a ubiquitous danger, not just necessarily a specific workplace danger, which is where the guidelines would typically come out on from OSHA. So again, yeah, I mean, just kind of keeping with whatever the state comes out with. I don't necessarily have an answer as to employees that are concerned about returning to work, except, you know, documenting everything that you're doing, and then also just maintaining all of the guidelines, the workplace safety guidelines.
Awesome. So I think that we're going to open up some of the questions that have come in through chat. And so I'll start it off, and this for both of you, anyone that wants to chime in. So it says during COVID, this person paused their business operations and changed both their LLC and business name as well as their mailing address. And they're asking what steps or forms do they need to take with local and federal departments to get this finalized.
Sure. So I guess maybe I can take that unless you want to, Maria. But just so they changed the name of their LLC and
their location and their name and their location.
So if they have an existing entity that was formed in Colorado, then they would have to go through the Colorado Secretary of State website, and it's a fairly simple procedure to update the name and fill out those forms and the address. So it would be just a kind of a change form on the Colorado Secretary of State. And then from a federal perspective, I would assume unless you formed a new entity, you would stay with the same tax ID number. But you would need to make those updates as well. Maria, did I miss anything?
I don't think so.
Sounds good. So you
Colorado Lawyers Assistance, this group that has evolved during this pandemic is, you know, those are exactly the kind of questions that we can help you answer and guide you through, and we're happy to do so.
Awesome, thank you. So let's see here. There is one that is asking about, they've been paying their rent in full, but it's unlikely that they're going to return to full capacity. So they're looking into going towards a smaller space. That's probably going to be their end goal. So I guess they're wondering if you have any feedback or thoughts on that situation. I'm not sure if they mean within the same building or moving towards a different one, but
that's what I was going to ask as a follow-up. If they're thinking about a smaller space and maybe surrendering some of their space there, again, I think this is all conversations that they need to be having with their landlord. If what they mean is we want to get out of our lease and then go to a new space, then they would have, I mean, again, there may be some landlords that are like, fine, just give me back the space. But the reality is they're still under obligation under the lease unless landlord agrees to let them go. So maybe that's one option, just asking landlord to reduce the space, and you know, they would have to do some work to do that, or maybe landlord has another space that is available. And I think they can use that as a bargaining power tool to say, you know, we've been paying rent in full, we've been really good tenants so far. Can you work with us here? And also, it depends how much. This is all strategic, right? It's not really like interpreting any lease, but how much longer do you have on your lease? Can you maybe offer landlord a longer term in return to move into a smaller space? Or if you have only a few months left, can you just wait it out and move to a completely different building? So all those considerations, again, we can help specifically in their case, but there's really no straight answer without knowing the particulars. But there's definitely room for different options.
I would just quickly piggyback on what exactly, and Maria is the expert on all of that, but just that, you know, a lot of people I think that it's all legal, and obviously, you know, if you have a contract, then you have to typically perform under that contract unless, you know, you have that force majeure clause or you have protection under the UCC codes. But a lot of it, there's a lot of this kind of soft approach to it, right? Which is more just on a very human level. And it's, you know, I think people just need to realize that you can approach your landlord or a vendor, you know, or whatever the other counterparty is and say, look, this is the situation. Can you work with me? And that is kind of really the first point of call, right, Maria? Like it's you know, everybody's kind of suffering.
Yeah.
On the same level.
Yeah, I absolutely agree. You know, unlike other circumstances that humanity has lived through, I think we are all being affected by this. So yes, I agree. Sometimes we are very so we've been helping a lot of people also with the residential leases, and you know, sometimes people are kind of, if not scared, very intimidated by the fact that they have a contract. Mm-hmm. But you know, contracts, like, of course, that's in place, like Jeff said, like that is what rules your relationship at the end. But we're all human beings, we're all going through things, so you know, contracts can evolve. There's in big commercial transactions, there's usually amendments. There usually is not. I mean, very rarely, and this happens, of course, when everything is going smoothly, like you sign a contract and you don't think about it for the next 10 years. But usually, I mean, people, I even wonder when I'm negotiating leases, like I know that sometimes there's conversations among the parties during the life of the contract where they, you know, come to an agreement about this instance or the other, and very rarely are they going back and looking into the lease and what exactly it says. So yes, that's I think, going back to my first advice, like just talk to the people that you need to be talking to, because what I've seen, unfortunately, is we're in July and a lot of people are just starting to think about this, and you know, 4 months have gone by during this whole situation. So you just, if you haven't talked to your landlord, just think about doing it sooner rather than later.
Yeah. And I mean, one of the basic tenets of, you know, when we in law school for contract law is in the common law jurisdiction, which is the US, is the freedom to contract, the meeting of the minds for parties to come together and put together a contract rather than like in a civil law jurisdiction. And sorry if that's geeking out a little bit on the law, but that's the beauty of it. It can be a very fluid relationship and document. So just don't be intimidated by it.
Awesome. So we have somebody that asked a question, and I'm going to bundle this. You know, there's, unfortunately, you know, we've been talking about contracts on, you know, a lot of like leasing and things like that, but there are there are some people that are trying to take advantage of small business owners, locking them in contracts. This example is credit card processing, like locking into a credit card transaction processing system that was misrepresented. But this person is basically asking, and I think it's a decent question to ask, there's the Better Business, the BBB website and PaySafe and things like that, but are there any other places or thoughts that you or recommendations you might have for business owners that may have, again, locked into maybe a contract for something that was false? Like, is there any protection for a small business owner if they lock in? And I'll use the example of this credit card processing company that misrepresented themselves.
Yeah, I mean, so obviously, if there were some kind of misrepresentations, whether fraudulent or negligent, that induced, again, sorry, very like legalese terms, but that induced you to enter into the contract but were not communicated to you. I mean, that's all, it's either done through I mean, it's a contractual sort of remedy that you could use to terminate, but it's not, you're not quite as empowered to do it as an individual without having kind of a lawyer represent you and going to litigation and taking all of those, or mediation or arbitration or whatever it is in that particular agreement. The BBBB unfortunately doesn't have very strong teeth. And then obviously you have got like Google reviews and social media. What is interesting though, and this kind of a non-legal approach that I've seen be successful for a lot of kind of aggrieved customers and people who have entered into contracts that can't get out or that can't get their deposit back or things like that, is to, and this is just, again, totally non-legal, but it's just to keep contacting kind of the higher ups in that organization. So I've seen people email, or I've heard stories, successful stories of people emailing the CEO of Expedia or of airlines to try to get their money back. And because they're persistent, and these bigger companies, are conscious of their reputation, they've been successful in getting some kind of, either getting their money back or getting some kind of a remedy to rectify that situation. So that again is not a very kind of legal avenue, and the legal avenue unfortunately is more costly, more time consuming, resource consuming, but in these kind of soft self-help ways, that seems to be successful during this time.
Thank you.
Great, thank you. So we do have another question that might just be another clarifying or repeat, but it was for a lease buyout. They're saying, are people figuring that based on a percentage of what's left remaining on the lease? Or can you explain that a little further?
Yeah, it depends on the situation. I just negotiated a buyout where, tenant is very well positioned. They just wanted to move neighborhoods, and they basically paid all the remainder of the rent plus a little more, and landlord was very happy. In some other cases, landlord may be comfortable with payment, and of course I'm making these scenarios as I go, but for example, they may be comfortable with receiving 4 months of rent if landlord anticipates to be able to get the space occupied within 4 months. Another thing that I forgot to mention that does not relate to buyout is subleasing. If your lease has a good, by good I mean a tenant favorable provision where it allows you to sublet the premises, that is another good option, or assign the lease. So you can see different scenarios in this. Some leases, I gotta say that I think this is the minority of leases, say no assignment or subletting whatsoever. Some other leases say no assignment unless you request the landlord's consent, which consent may be withheld in landlord's sole discretion. Not very helpful unless your landlord is, you know, reasonable business people. And then the other one goes, and a lot of retail leases, especially if you got it well negotiating during at the beginning, will say you can assign or sublet with landlord's prior consent, which consent may not be unreasonably withheld, condition, or delay. And some even go to, you know, list a number of factors that landlord can consider and where it would be reasonable for landlord to withhold its consent. For example, financials, the reputation of the new tenant, and all that. And some even have a permitted, that's the other level, it's some have a permitted transfer provision where you can assign to an affiliate or, but again, if you're a small business, maybe there's not an affiliate. You do have to look into your lease if you are a franchisee. A lot of these leases will have provisions that say that the parent company or the franchisor or any other affiliate, you know, any other franchisee in the area has like a permitted transfer provision where they can take over on the lease. That said, I don't know, I've heard that some franchisors are getting pretty aggressive with their franchisees. So you would have to, you know, assess their willingness to take on the lease. But that is something, and I'm sorry that I didn't mention it before, but that is something that you should really be thinking about in case that you are trying just to get out of the lease. And think about where, and a broker, I mean, you could do this yourself, or you can employ a broker to try to find someone, another business that would be a good fit. Just so you know, like landlord will take into consideration, for example, the mixed use of the building. If this is retail and you run a restaurant, they're not gonna want another, and there's a restaurant next door, they're not gonna want another restaurant probably, but who knows? I mean, and you know, it's a little bit difficult to find subtenants right now, but remember that there's always opportunistic investment going on, and there's always people, because then keep in mind that you would probably sublease at lower rates than your rates, and you would probably have to eat the difference, unless landlord, of course, lets you, and you would, in most instances, you would remain liable under the lease. So you would also don't want to just sublease it to anyone. You would want to do your own diligence and make sure that this company is going to perform, because otherwise, unless otherwise stated, you would be liable under the lease. So that is definitely something to think about. And, you know, if there's lower rates, there may be businesses looking for subleasing space. If it's office, same thing. We expect to be working on a lot of subleases. We have already started, but we expect to see a lot of subleasing work for office space, because companies are realizing that they don't need as much space as they had. And again, you could get, I'm not sure, I'm not a broker, so I haven't seen if there's been much movement yet, but I would imagine there's going to be some, you know, significantly lower rates available in some time. Have you seen anything, Jeff?
I actually, again, out of my industry or my expertise, but I do have a question for you that may be relevant for the audience as well. So in the sublease type situation, what kind of indemnification provisions can you have as between the
tenant and sublessor and sublessee? Yeah, so usually you will add some provision that says that anything that arises before the sublease is going to be the responsibility of the tenant. And then anything that arises after the sublist date will be the responsibility of the new tenant, so of subtenant. So it really depends on how you structure this, but most likely this is not going to be a binding indemnity provision against the landlord. So the landlord will continue to it will most likely retain its rights to go after either or both. Unless, of course, like I said, there's some sort of, you can try to use, you can think about, you know, a subtenant can provide a personal guarantee, or a subtenant can provide a letter of credit, or you know, a generous security deposit, or try to negotiate, or you know, sell your tenant your subtenant really well to the landlord, so that they see, okay, we shouldn't be concerned, we'll let you off the hook, but again, generally you remain liable. But it's worth asking. And I'm not sure. Yeah,
just one more thing to add, and again, kind of from a contractual perspective, there's a difference between an assignment, right, a subtenant agreement, and a novation in terms of the liability that you carry forward.
That's right. And sometimes if you assign the lease, you're more likely to be released from the liability. A lot of leases are drafted to, you know, in a way that, you know, regardless of any assignment, unless landlord agrees otherwise in writing, tenant will remain liable. Mm-hmm. In the sublease, you basically, continue to be the tenant. And so you are obligated under the lease as if you are the tenant. You just happen to have the subtenant who's using the premises. And you know, it's more they'll ask them to pay directly to the landlord and all that, but you are still the tenant under that lease. So if you have any specific questions and would want to explore whether that is a possibility for you based on how your lease reads, again, submit some your specifics to the Colorado Lawyers Committee, because it is worth exploring, unless you really think that it's going to be very tough to find a subtenant. And in the buyout, like I said, just talk to your landlord. I mean, that's where you have to make your analysis of what is going to be the less costly option. And it may be that landlord is happy with a few months rent, but again, in theory, you're obligated to comply with the full term of the lease.
Great. Well, thank you both so much for doing today's panel, and I think this has been really helpful. I know there were a lot of questions, and you know, it's a tough time for so many people right now, and there's a lot of questions out there, and you know, things that nobody's faced. So I appreciate you taking the time to you know, walk through some of this. So if people do want to get in touch with the Colorado Lawyers Committee, is it best to just go to that website that we have listed and apply, or how does that work?
That is correct. So if you go to coloradocovidrelief.org, you can submit an application, and how they're doing it is every Tuesday and maybe every Thursday, but definitely every Tuesday, they're sending the list of you know, of small businesses and their particular issue, and then they send it to the people that have shown interest in assisting, and then they do the matching, and basically then you are being advised specifically on your issue, and the Colorado Lawyers Committee gets out of the middle. You run your conflicts as a firm to make sure that there's no conflicts, and then they become your client on a pro bono basis. So don't be afraid. I mean, this is tough times for everyone, and I think a lot of attorneys have the skills and really the desire to give back, especially transactional attorneys usually don't have a lot of pro bono opportunities that relate to their specific fields. So this is good for everyone. Don't feel like a burden. This is good for everyone. Attorneys are getting, practicing their skills and all that as well. So don't feel bad about submitting that.
And then just to add on to that as well, you won't be pressured to, like, there won't be kind of a sell situation where you have to then engage with that firm or that attorney. And I know that, that's definitely on a lot of people's minds. So there won't be any kind of a hard sell. This is purely pro bono, which is, free legal advice. And we are committed as professionals to provide a certain amount of pro bono hours annually. So yeah, we're very happy to do it, especially transactional attorneys. I've been to a lot of legal clinics and I just haven't been able to use my skills. So yeah, please do feel free to reach out.
That's fantastic. So thank you both for volunteering for that program. I think it's really great, and hopefully small businesses can benefit from it. And so all of you on the call, encourage you to check that out if you do have more questions. Also, again, just to reiterate what Susie said earlier, there are 15 SBDCs across the state. So if you are dialing in from somewhere other than Boulder, you can visit coloradosbdc.org to find your local center and get some help with free consulting and resources through that. We are recording today, like we said, so we will post that on our website and get information out to you tomorrow. And we do have another webinar next week on the PPP forgiveness, which I know is still a question on a lot of people's minds. So thanks again for participating today, and thank you, Maria and Yev. We loved having you. So have a good day.
Thank you so much.
Thank you for putting together. Goodbye.
Bye.
Thank you. Bye-bye.
Bye.